Hello, everyone. My name is Jason Cornell. I'm a disability attorney with Ligio and Cornell. We handle disability claims throughout the United States, and we're located in West Palm Beach, Florida. I want to talk to you today about a case where a court awarded disability benefits to a personal injury lawyer who was suffering from depression and anxiety. The reason I think this is relevant is research has shown that over 10% of Americans suffer with some form of depressive disorder. And that number spikes to 17% when you look at young adults and teens who suffer from depression. So this case is called Messing versus Provident Life and Accident, and it went up to the Sixth Circuit Court of Appeals. That's one step below the U.S. Supreme Court. And just to tell you a little bit about this case, the attorney there, he purchased a long-term disability policy in 1985 with Provident Life, and he was doing fine until about 9 years later, in 1994, and he began experiencing symptoms of depression and anxiety. At first, they were mild. His symptoms were mild, but over time, it worsened to the point where the attorney had to be hospitalized for 25 days. And so he made a claim for disability benefits under his policy. Initially, the insurer said, okay, we're going to pay your disability, and they did. But they reversed course later and said, no, we're going to deny benefits for your disability based on depression and anxiety. So the employee eventually sued in federal court, and the insurer reversed itself again and said, we're going to pay benefits. But in 2018, the insurer, Provident, reviewed the claim once again, see if the employee was still disabled. And that's something that happens commonly, is once they approve a claim, a year, 2, 3 years later, they will review the claim to see should they continue paying benefits. And in doing that, they had a doctor interview this attorney for over 2 hours. And the doctor agreed with the diagnosis that he had major depressive disorder. But the doctor said at the time I interviewed him, he was not showing any symptoms. So based on the insurance company's doctor's opinions, they denied the claim. And the attorney, the plaintiff's attorney who suffered from depression, he filed an internal appeal with the insurer. That was denied. And then, having exhausted his remedies, he again filed a lawsuit in federal court. And the federal judge actually upheld the denial by the disability insurer. So the attorney went one step further, and he appealed to the Sixth Circuit Court of Appeals. And there, the appellate court reversed the federal trial judge. So the appellate court said, no, in fact, this attorney is disabled and he is entitled to benefits. So the appellate court actually reversed the trial judge below, which is not unusual. And in doing so, it looked and considered all of the evidence that was record evidence, meaning the evidence that was put before it. And some of that evidence showed that there were opinions by doctors that supported the denial by the insurer. The court acknowledged that. There were some doctors who said he was not disabled, as that term was defined under the policy. But there was other evidence the court took in consideration that showed he was, in fact, disabled under the policy. And that had greater weight to the court as far as in considering whether to reverse the trial court or uphold the denial. So the appellate court believed, no, this attorney was disabled, and it even said, all doctors acknowledged the fragile state of the attorney, and the appellate court also wrote he should be mindful to avoid stressful environments to prevent a relapse into a worse state of depression. So they were quoting his providers saying that he could easily relapse into a worse state of depression. And so the court, having taken all the evidence, found that the attorney, by a preponderance of the evidence, remains unable to work. And there's one last quote I want to read to you from the appellate court I found it was interesting. It says, the definition of disability meant that the insured is not able to perform the substantial and material duties of the occupation regularly engaged at the time he becomes disabled. So we are not talking about a fractured spine. We're not talking about a broken leg. We are talking about a mental health disorder. And the appellate court, the Sixth Circuit Court of Appeals, said, yes, an employee suffering from that condition can satisfy the definition of disability because he was unable to do the functions of an attorney. And the court also acknowledged that the attorney, like many other professions, is a very high-stress job where you are in an adversarial setting with opposing counsel, you are making arguments to the court, you are dealing with sensitive client issues under deadlines. So the opinion makes sense. And I'm happy for this employee that he was able to get benefits, or this attorney, even though he had to take it all the way to the Sixth Circuit Court of Appeals. So I hope this was helpful for you. If you ever have questions, no matter where you're located throughout the United States, if you have questions about your disability claim or how it's been handled or whether you even qualify for disability coverage, by all means, give us a call. We'd be happy to talk to you. So I want to thank you for being here today, everyone, and have a good afternoon.